we want to go back to each of you on your thoughts. I know we spoke about this, and I'm assuming the answer is going to be, just use caution, better safe than sorry. But wanting to know, is there anything at all that can be done to respond to perhaps an untrue post that's seen on social media, or is the council here to just stay away from it either way? And I want to ask each of you your thoughts on that. Dennis, we'll start with you as you covered that.
That's a great question. And start with the assumption that your state rule doesn't cover this and doesn't allow a lawyer to respond to social media criticisms. There are one or two states who have changed their rule to permit it. Most states have not. Going back to the ABA opinion 496, actually that question is taken up at the end of the opinion, and the opinion says, look, as far as we can tell, and the ABA Ethics and Professional Responsibility Committee, these are pretty smart people. They say all you can really do is ask the website host or the search engine to remove the post. They say you can do that. Or you can get in touch with the client or the person who has posted this, and the quote that comes out of the opinion is, please contact me by telephone so that we can discuss your concerns. And lastly, if you feel that you must respond, the opinion says you can say, quote, professional obligations do not allow me to respond as I would wish, unquote. So there you go. There's essentially no online remedy for the lawyer who is the object of this. But I will tell you, the argument that I am making in the case that I have is my lawyer client, who was the subject of stuff that was just completely untrue. I said, my client does have a remedy. He can sue the former client for defamation. And if he sues the former client for defamation, then all of this stuff can be aired publicly, or at least the stuff related to the dispute. And my argument is, and it's going to end up having to be made to the Nevada Supreme Court, is that what you're telling lawyers? That the interpretation of the rule is you can't say anything online, but you can sue for defamation per se if they attack your profession and your professional qualifications. Is that what the rule means? It can't mean that. It can't say to people, you can't respond, but go out and sue for your response. But right now, in my state, virtually every other state, you can see it in the ABA opinion, there is nothing you can do except ask that the post be taken down, or say, I'm responding, but I can't respond because of professional obligations. Boy, that's not much of a remedy, but that's the way
Elizabeth?
It is now.
Yes, Randy.
I've actually handled a couple of defamation cases for lawyers in this situation, and one of the things lawyers need to know is that there is a constitutional right to make anonymous comments, and that's the big problem lawyers have, is they don't know who to sue even. They don't know who said these bad things. Sometimes, in Dennis's case, obviously he knows, but you don't always know. And there's a case out of Washington State and I think maybe Delaware. I'm not sure the other case, but two cases have been decided that give guidelines as to when you can force the internet provider to disclose the identity of the online, otherwise anonymous online reviewer. And it is a high bar. just suing for defamation itself is not the remedy that you would like it to be, but it is out there and we have used it.